Hello, today I want to talk about something that is deeply disturbing that has happened in our Phoenix immigration courts and can affect thousands of immigrants across the country. Okay, so last week in Phoenix Immigration Court, as well as in San Francisco, in New York City, in Miami, in Seattle, people showed up for their immigration hearings. These are non-citizens who had pending asylum cases in court. They show up and they find out from the immigration judge that their cases are going to be dismissed. Why? Because the Office of Principal Legal Advisor, known as OPLA, decided to dismiss their cases. So generally this sounds like great news. You no longer have a case in court, you can go home. They leave the courtroom and they are met by ICE officers who are in plain clothes, right outside the courtroom or in the parking lot, and they are placed in handcuffs. Let me be clear, in all of my years as an immigration attorney, I have never seen such a policy in place. Not under Obama, not under Trump 1.0. This is a very new and aggressive tactic. So what happened? Well, in January 2025, Trump signed a new executive order called Protecting the American People Against Invasion. And what this order does is it dramatically expands the policy of expedited removal, which allows ICE to remove people without giving them due process or a day in court. Okay, so what is expedited removal? It was created by Congress in 1996, and what it allows is for ICE or CBP, Customs and Border Patrol, to rapidly deport people, non-citizens, who enter the US without inspection and without admission. Additionally, those people have to have been present in the US for less than 2 years, and they cannot prove that they have been here for longer than 2 years. So what Trump did is he actually expanded this policy so that ICE and CBP can use it anywhere in the country, not just near the border. Now, I'm sure if you have a pending case in court, you are probably asking yourself, should I even go to court now? Maybe I shouldn't go. You're probably feeling fearful. Well, to help you answer that question, you should know what could happen if you don't go to court. So if you do go to court, it is possible that yes, you could be detained by ICE. But if you don't go to court, it's also not just possible, but what will happen is you will have an in absentia order of removal put into effect by the immigration judge. And this will harm your chances of ever coming back to the United States, even if you have a valid claim. So what can you do if you do have a court hearing? Well, number one, you should definitely bring a person to come with you, preferably a US citizen or lawful permanent resident, who can tell your other family members and alert them in the case that you are actually detained. Number two, if you are detained, you do not want to speak to ICE directly. Tell them that you have an attorney or you want to hire one. And number three, if you are detained, you should tell them that you are afraid to return to your home country and that you want to apply for asylum. Why? Because this will trigger a credible fear interview, also known as a CFI, and provide a basis of relief for you to stay in the United States. Thank you so much for listening to my video today. If you found it helpful, please do share it with other people you know. Definitely subscribe so you can get some updated material and updated immigration news. And if you or a loved one need help, please reach out to me directly.